In the autumn of 1870, a woman was taken from her lodgings in England and delivered to a large stone building near Bristol. She had not committed any crime. She had not harmed herself or any other person. She was not, by her own account or by the observations of those who knew her, suffering from any disorder of the mind. Yet within hours of her arrival, she found herself locked in a room among strangers, her letters intercepted, her protests dismissed, her liberty removed as completely as if she had been convicted of the gravest offense. Her name was Louisa Lowe, and she would spend nearly 2 years confined in private lunatic asylums, passed from one institution to another, while the law that should have protected her instead held her captive. This is the story of her imprisonment, her struggle to be heard, and the mystery of how a woman of sound mind could simply vanish into the silence of the asylum system. Good evening and welcome. What follows is a quiet tale, told without haste and without any sudden sounds. The voice you hear will remain steady and calm throughout. There will be no raised tones, no jarring interruption. If you find comfort in these stories and wish to return another evening, you will find us here, always with a tale waiting. For now, you need do nothing at all. Close your eyes whenever you wish. Let your breathing slow. Let your thoughts settle. Brislington House stood on rising ground a few miles from Bristol, its long facade visible across the fields in certain lights, its windows catching the afternoon sun. It was a substantial building, solid and respectable in appearance, with grounds that stretched toward hedgerows and a scattering of old trees. To a passing traveller, it might have seemed a gentleman's residence, perhaps the home of a prosperous family with land. Only on closer approach did certain details reveal its true purpose. The bars set into some of the upper windows, the high walls enclosing portions of the garden, the particular stillness that hung about the place even on fine days. This was a proprietary asylum, one of many such establishments scattered across England in the middle years of the 19th century. These were private institutions, licensed to receive paying patients, operated for profit by medical men or their families. They occupied a peculiar place in the landscape of Victorian society, neither quite hospitals nor quite prisons, yet sharing characteristics of both. The patients who arrived at their doors came not by their own choice but by the decisions of others, relatives, doctors, sometimes strangers. Once inside, they found themselves subject to rules they had not agreed to, confined in rooms they could not leave, their correspondence scrutinized, their movements the world outside continued without them, and in many cases, the world outside forgot them entirely. Brislington House had a long history. It had received patients for decades, its reputation neither especially notorious nor especially distinguished. It was simply one of many such places, part of a system that had grown up piecemeal over the years, shaped by laws that gave broad powers to those who signed the necessary papers and limited recourse to those who found themselves on the wrong side of the locked door. The fees were considerable. A patient of means might pay £200 a year or more for the privilege of confinement, a sum that represented a comfortable annual income for many families. The money flowed from relatives or trustees or solicitors, and the patient remained, month after month, year after year, until someone with authority decided otherwise. The grounds at Brislington were pleasant enough in their way. There were paths for walking, benches set beneath the trees, views across the surrounding countryside. Patients who were deemed sufficiently calm were permitted to take the air at appointed hours, always under supervision, always within. The gardens were tended, the hedges trimmed, the gravel paths raked smooth. It was a place designed to present an appearance of order and tranquility, a place where the outside world might imagine its troublesome relations were being cared for in comfort and safety. What happened within the walls, behind the barred windows and the heavy doors, was another matter. The building itself was arranged in the manner common to such institutions. There were separate wards for men and women, corridors lined with doors that could be locked from the outside, day rooms where patients gathered under the eyes of attendants, and single rooms, sometimes called cells, where individuals slept and where those deemed difficult or dangerous could be confined for hours or days at a time. The locks were heavy, the keys carried by keepers and matrons, the routine governed by bells and schedule. Patients rose when told, ate when told, walked when told, and retired when told. The rhythm of the day was not their own. In September of 1870, a new patient arrived at Brislington House. She was a woman of middle years, the wife of a clergyman, accustomed to the quiet routines of a country vicarage. Her name was Louisa Lowe. She had not asked to come. She had been collected from her lodgings by an attendant, a woman she had never met, and brought to this place without warning or explanation. The journey had been long, the destination unfamiliar, and when she passed through the doors of the asylum, she entered a world from which escape would prove extraordinarily difficult. Louisa Lowe was, by her own account and by the observations of those who examined her, entirely sane. She was articulate, educated, and capable of reasoned conversation. She had committed no act of violence, threatened no harm, exhibited no confusion or delusion that any impartial observer could detect. Yet here she was, locked in a room among strangers, her protests ignored, her letters intercepted, her liberty taken from her by the stroke of a pen. The law of England as it stood in 1870 permitted this. 2 signatures from registered medical practitioners, an order from a relative or other interested party, and the thing was done. No court was required, no hearing, no opportunity for the subject to speak in her own defense. The asylum doors closed, and the world moved. The rooms at Brislington were not uncomfortable by the standards of the time. There were beds, chairs, tables, fires in the grates when the weather turned cold. The food was adequate, the attendants not uniformly unkind. But comfort is a relative thing, and for a woman who knew herself to be sane, who had been taken from her home without consent, the trappings of respectability were small consolation. The locks on the doors, the bars on the windows, the constant supervision, the inability to send a letter without it being read and perhaps withheld, these were the realities of life in a proprietary asylum, and no amount of pleasant gardens or adequate meals could disguise them. Louisa Lowe would later write of her time at Brislington and the institutions that followed. She would describe the sounds of the place, the turning of heavy locks, the footsteps of keepers in the corridors, the cries of other patients in the night. She would describe the smells, the close air of rooms that were rarely ventilated, the odors of bodies and illness and confinement. She would describe the routines, the bells that marked the hours, the walks at appointed times, the meals served without variation, the long evenings in rooms where the fire was extinguished promptly and the cold crept in. She would describe the people, the other patients, some clearly unwell, others seemingly as rational as herself, the attendants, some kind, some indifferent, some cruel, the doctors who came and went and made their notes and rarely listened. But all of that was yet to come. In September of 1870, Louisa Lowe was simply a new arrival, one more name in the register, one more patient. The world outside did not know where she was. The world outside did not know to ask. And in the quiet of the asylum, surrounded by strangers, she began the long work of trying to make herself heard. Brislington House held its secrets well. The walls were thick, the grounds enclosed, the staff accustomed to discretion. Patients came and patients went, and the rhythms of the institution continued undisturbed. The commissioners in Lunacy, those officials charged with overseeing such establishments, visited from time to time, inspected the premises, interviewed selected patients and departed. Their reports were filed, their recommendations noted, and the asylum carried on much as before. It was a system that functioned smoothly, efficiently, and with remarkably little scrutiny from the outside. For those who found themselves inside, the experience was rather different. This is a story that begins in a place of apparent calm, a building set among fields, a routine that seemed orderly and humane, but beneath the surface questions lingered. How had Louisa Lowe come to be here? What had been written on the certificates that authorized her confinement? Who had signed the order and why? And how was it possible, in a nation that prided itself on the rule of law and the liberty of the subject, for a woman of sound mind to be locked away without trial, without hearing, without any means of appeal? These are the questions that would occupy her for years to come, and they are the questions that this story will, in its own time, attempt to answer. For now, it is enough to know that the doors of Brislington House had closed behind her, and that the long silence of the asylum, the England of 1870, was a nation of sharp contrasts, a place where wealth and poverty existed side by side, where progress and tradition jostled for position, where the certainties of one generation gave way to the uncertainties of the next. The railways had stitched the country together, carrying goods and people at speeds unimaginable. The cities had swelled with workers drawn from the countryside, their streets crowded, their factories loud with machinery, their air thick with smoke. London, the capital, was the largest city in the world, a vast sprawl of neighborhoods and districts, each with its own character, its own rhythms, its own secrets. Yet for all the changes that industrialization had brought, the structures of society remained remarkably fixed. Class was the organizing principle of English life, a ladder with many rungs, each carefully distinguished from those above and below. At the top stood the aristocracy and the landed gentry, their wealth rooted in land and inheritance, their influence felt in Parliament and the professions and the church. Below them came the middle classes, a broad and varied group that included merchants, manufacturers, doctors, lawyers, clergymen, and the many others who lived by education and enterprise rather than manual labor. Below them still came the working classes, the men and women who toiled in factories and fields and domestic service, whose lives were shaped by the demands of employers and the vagaries of the. And at the bottom, often invisible to those above, came the poor, the destitute, the vagrant, the mad. The word mad carried a particular weight in Victorian England. It was a term that could be applied loosely or precisely, sympathetically or with contempt, depending on the speaker and the context. To be deemed mad was to be set apart from ordinary society, to be marked as different, as dangerous, as in need of control. The law recognized various categories of mental incapacity, from the harmless eccentric to the raving lunatic, and it provided mechanisms for dealing with each. For the wealthy, there were private asylums, proprietary establishments where patients could be confined in relative comfort at considerable expense. For the poor, there were county asylums, large public institutions maintained by local rates, where conditions were often harsher and oversight more. And for those who fell between, there were workhouses, charitable institutions, and the uncertain charity of family and neighbors. The lunacy laws of England had developed over many years, a patchwork of statutes and precedents that gave broad powers to certain individuals and limited protections to others. At the heart of the system was the certificate, a document signed by a registered medical practitioner attesting that a particular person was of unsound mind and in need of confinement. Two such certificates, together with an order signed by a relative or other interested party, were sufficient to commit a private patient to an asylum. No court was required, no judge, no jury. The decision rested with the doctors who signed the certificates and the person who signed the. Once the papers were complete, the patient could be taken to an asylum and held there indefinitely, subject only to the periodic inspections of the commissioners in lunacy and the discretion of the asylum's proprietor. The commissioners in lunacy were the official overseers of the system, a body of men appointed to inspect asylums, review certificates, and hear complaints. Their offices were located at 19 Whitehall Place in London, a respectable address in the heart of the administrative district. They visited licensed houses at intervals prescribed by law, examined the premises, spoke with patients, and filed reports. In theory, they were the guardians of the liberty of those confined, the check on abuses, the voice of reason and humanity in a system that might otherwise tend toward cruelty and neglect. In practice, their powers were limited, their resources stretched, their sympathies often aligned with the proprietors and doctors whose establishments they inspected. They were, after all, part of the same world, educated men of the professional classes, inclined to trust the judgments of their peers and to view the complaints of patients with a certain skepticism. For a woman in Victorian England, the lunacy laws carried particular risks. Women were understood, in the thinking of the time, to be more susceptible to disorders of the mind, more prone to nervous complaints, more likely to succumb to the pressures of domestic life. The medical literature of the period is full of references to female hysteria, to the delicate constitution of the weaker sex, to the dangers of excessive education or insufficient occupation. A woman who expressed unconventional opinions, who challenged the authority of her husband or her family, who exhibited religious enthusiasm or spiritual interests outside the mainstream, might find herself labeled as unstable, as in need of rest and supervision, as a candidate for the asylum. The certificates required for commitment asked only for evidence of unsound mind. They did not require proof of danger, of violence, of any specific act. A doctor's opinion based on a brief examination or the reports of interested parties was sufficient. The financial dimensions of the system were considerable. Proprietary asylums were businesses, operated for profit by their owners. The fees charged to patients or their families could amount to £200, £300, even £400 a year, sums that represented substantial incomes in an age when a skilled worker might earn less than £100 annually. For the proprietors, a full house meant a healthy return on investment. For the relatives who paid the bills, the arrangement offered a solution to difficult domestic situations. An inconvenient wife, an embarrassing aunt, a troublesome daughter could be removed from view, cared for at a distance, and largely forgotten. The patient, meanwhile, had little recourse. Letters could be intercepted, visitors discouraged, complaints dismissed as symptoms of the very madness that justified confinement. This was the world into which Louisa Lowe was delivered in September of 1870. She was a clergyman's wife, a woman of the educated middle class, accustomed to the routines of a country vicarage and the quiet rhythms of provincial life. She had lived at Outlawry, near Honiton in Devon, a small parish in the rolling countryside of the West Country. Her days had been shaped by the duties of her station, the management of the household, the support of her husband's ministry, the obligations of parish life. It was a life of modest comfort and limited horizons, bounded by the expectations of her class and her sex. How she came to be taken from that life and delivered to Brislington House is a question that would occupy. The certificates that authorized her confinement made reference to certain statements she was alleged to have made, to certain beliefs she was alleged to hold. She was said to have called herself a medium, to have claimed that she could only write as God moved her fingers. She was said to have alarmed her landlady by ringing for a light in the night and asking whether some animal had got in. These were the grounds, such as they were, on which 2 doctors had signed their names and declared her of unsound mind. To Louisa Lowe, these allegations were distortions, misunderstandings, or outright fabrications. She denied having made the statements attributed to her, or at least denied having made them in the sense implied. She insisted that she had been entirely rational, entirely capable, entirely fit to manage her own affairs. But her protests carried little weight. The certificates had been signed, the order had been given, and the doors of the asylum had closed behind her. The law did not require that she be heard before her liberty was taken. The law did not require that she be given an opportunity to answer the charges against her. The law required only that the proper forms be completed and the proper fees paid. In the asylum, she found herself among strangers, Other patients, some clearly unwell, others seemingly as rational as herself, attendants and keepers whose authority over her daily life was absolute, doctors and proprietors who came and went and made their notes and rarely listened. She was told when to rise, when to eat, when to walk, when to sleep. Her letters were read before they were sent, and many were never sent at all. Her requests for legal assistance were ignored. Her appeals to the commissioners were met with polite indifference. She was, in every practical sense, a prisoner held not for any crime but for the convenience of others, sustained only by her own conviction that she was sane, and that the truth, if she could only make it heard, would set her free. The mystery of Louisa Lowe's confinement was not a mystery of violence or sudden disappearance. It was a quieter thing, a mystery of paperwork and procedure, of signatures and seals, of a system that functioned smoothly and efficiently, and with remarkably little regard for the liberty of the individual. It was a mystery that would take years to unravel, and that would never be fully resolved. But it was also a mystery that would, in time, become a cause, a rallying point for those who believed that the lunacy laws of England. And at the center of that cause stood a woman who refused to be silent, who refused to accept the judgment of doctors and commissioners, who insisted, against all the weight of authority, that she knew her own mind. Louisa Lowe was not a woman accustomed to public attention. She had lived the greater part of her life in the quiet obscurity of a country vicarage, her days shaped by domestic duties and parish obligations, her world bounded by the hedgerows and lanes of rural Devon. She was educated, literate, capable of reasoned argument and clear expression, but these were qualities that, in a woman of her time and station, were expected to be exercised in private, in the service of family and household, not in the public arena. The role of a clergyman's wife was one of support and discretion, of quiet usefulness rather than conspicuous achievement. Louisa Lowe had filled that role for years, and nothing in her earlier life suggested that she would one day stand before a London audience and speak of her own suffering. Yet that is precisely what she did. On the 17th of July, 1873, in the Cavendish Rooms on Mortimer Street in London, Louisa Lowe delivered a speech that she titled My Outlawry. The room was filled with listeners, men and women of the educated classes, drawn by curiosity or concern or sympathy. They had come to hear a woman speak of her own experience, to learn what it meant to be confined in a private lunatic asylum, to understand the workings of a system that most of them had never encountered and few had reason to question. Louisa Lowe told them. She spoke of being taken from her lodgings without warning, of being delivered to Brislington House among strangers, of finding herself locked in a room with no means of. She spoke of the certificates that had authorized her confinement, of the allegations they contained, of her conviction that they were false or distorted or based on misunderstanding. She spoke of the years she had spent in one institution after another, of the letters she had written, and the letters that had been intercepted, of the interviews with commissioners that had led nowhere, of the legal proceedings that had failed. She spoke calmly, clearly, without theatrical emotion, presenting her case as she might have presented an argument in a court of law. She was not asking for pity, she was asking for justice. The woman who stood before that audience was not the same woman who had been taken to Brislington 3 years earlier. The experience of confinement had changed her, hardened her, given her a cause to which she would devote the remainder of her active life. She had emerged from the asylum system not broken but determined, not silenced but articulate, not defeated but resolved to make her story heard. She had become, in her own words, an outlaw, a woman who had been placed beyond the protection of the law by the very mechanisms that were supposed to safeguard her liberty. And she had decided that if the law would not protect her, she would expose the law. Before her confinement, Louisa Lowe had been, by all accounts, an ordinary woman of her class. She had married a clergyman, lived in a vicarage, occupied herself with the duties expected of her station. She had interests that might have been considered unconventional by some: a sympathy for spiritualism, a belief in the possibility of communication with the unseen, a willingness to speak of God's guidance in terms that some might have found excessive or peculiar. These were not uncommon interests in the middle years of the 19th century. Spiritualism had attracted many adherents, including people of education and standing, and the boundaries between religious enthusiasm and heterodox belief were often blurred. But for a woman, such interests could be dangerous. They could be taken as evidence of instability, of a mind unmoored from reason, of a temperament in need of correction. The certificates that had authorized Louisa Lowe's confinement made reference to such matters. She was said to have claimed that she could only write as God moved her fingers. These were the statements, or alleged statements, that had been offered as evidence of her unsound mind. To the doctors who signed the certificates, they may have seemed sufficient. To Louisa Lowe, they were a travesty, a misrepresentation of her beliefs, a pretext for an action that had nothing to do with her mental state and everything to do with the convenience of others. Who those others were, and what their motives might have been, she did not say explicitly in the portions of her testimony that survive. She spoke in general terms of the ways in which the lunacy laws could be used to dispose of inconvenient relatives, to gain control of property, to silence dissent within family. She described cases she had encountered during her confinement, other women whose stories resembled her own, women who had been certified on the flimsiest of pretexts and held for years without recourse. She made clear that her own case was not unique, that it was part of a pattern, a system that operated with the appearance of legality but without the substance of justice. The biographical details that survive of Louisa Lowe before her confinement are sparse. She does not describe her childhood, her education, her courtship, or her marriage in the texts that have come down to us. She does not speak of children, of close friends, of the particular joys or sorrows of her domestic life. What we know of her comes largely from what she chose to reveal in her public writings and speeches, and what she chose to reveal was shaped by her purpose: to expose the abuses of the lunacy system and to advocate for reform. She was not writing a memoir. She was making a case. What we can say with confidence is that she was a woman of intelligence and determination, capable of sustained effort and clear thought under circumstances that might have broken a weaker spirit. She kept notes during her confinement, recording conversations, observations, details of daily life that she would later use in her writing. She studied the law, reading court cases and parliamentary reports, educating herself in the technicalities of lunacy procedure so that she could argue her case on its own terms. She wrote letters, dozens of them, to solicitors, to commissioners, to anyone who might be able to help. Most of those letters were intercepted or ignored, but she kept writing. She did not give up. After her release, she continued her work. She became the honorary secretary of the Lunacy Law Reform Association, an organization dedicated to changing the laws that had permitted her confinement. She wrote pamphlets and books, including The Bastilles of England, a detailed account of conditions in proprietary asylums, and a critique of the system that sustained. She spoke in public, addressing audiences in London and elsewhere, telling her story and the stories of others, building a case for reform that would eventually contribute to changes in the law. The woman who did all this was not a radical by temperament or background. She was a clergyman's wife, a member of the respectable middle class, a person who might have lived out her days in quiet obscurity had circumstances not intervened. But circumstances did intervene, and she rose to meet. She took the suffering that had been inflicted upon her and transformed it into a cause, a purpose, a reason to go on. She refused to accept the judgment of the authorities who had confined her. She refused to be silent. She refused to disappear. If a descendant of Louisa Lowe were to hear this account, what would they find? They would find a woman treated unjustly by a system that gave her no voice, who nonetheless found a way to speak. They would find a woman who endured years of confinement without losing her sense of self, who emerged from the asylum not diminished but strengthened in her resolve. They would find a woman who devoted the years after her release to the cause of others, who used her own suffering as a lens through which to examine a broader injustice. They would find, in short, a woman worthy of respect, a woman whose story deserves to be remembered. The mystery of Louisa Lowe's confinement is not a mystery of the conventional kind. There is no body to be discovered, no murderer to be unmasked, no dramatic revelation waiting at the end of the tale. The mystery is quieter, more insidious, more difficult to resolve. It is the mystery of how a woman of sound mind could be taken from her home, locked in an asylum, and held for years without any meaningful opportunity to challenge her confinement. It is the mystery of how a system that was supposed to protect the vulnerable could instead be used to silence the inconvenient. It is the mystery of power exercised without accountability, of authority wielded without restraint, of law that served the interests of some at the expense of others. Louisa Lowe spent years trying to answer that mystery, to understand how it had happened to her and how it could be prevented from happening to others. She did not succeed entirely. The law changed in time, but slowly, and the abuses she described did not disappear overnight. Yet her voice was heard, her story was told, and her name became associated with a cause that outlived her. In the quiet of the Cavendish rooms, on a July evening in 1873, a woman who had been declared mad stood before an audience of strangers and spoke the truth as she understood it. That in itself was a kind of victory. The days inside a proprietary asylum followed a pattern as fixed as the turning of the earth. For Louisa Lowe, confined first at Brislington near Bristol and later in a large metropolitan house adapted for 200 patients, the rhythm of institutional life replaced the quiet freedoms she had known at Outlawry Vicarage. There in the countryside near Honiton, she had lived the measured existence of a clergyman's wife, her hours shaped by parish duties and domestic concern. Now her hours belonged to others, and the fragile connections that had once linked her to the world outside grew thin as winter light. A day in the large metropolitan house began before dawn, in the cold months at least. The night keepers slept in the corridors or sometimes in the rooms of patients deemed to require supervision. One keeper, Lowe noted, was a remarkably good snorer, and the sound of his breathing was among the small indignities of the night. The cells, as the single rooms were called, had heavy doors fitted with jail locks, and these were turned repeatedly after patients retired. At 9 in the evening, the women were taken to their rooms and locked in. Half an hour later, the keepers made their rounds, checking each door, turning each lock with a harsh, grating noise that echoed along the passages. An hour after that, another inspection. The locks turned. Sleep, for those who could find it, came in fragments, interrupted by the sounds of the house settling into its uneasy rest. Very early in the winter mornings, before the sky had lightened, an atrociously loud call bell shattered the quiet. The night keepers rose, lit their candles, and began the work of preparing the house for another day. In the neighboring wards, patients startled into activity by the bell let out shrieks, songs and cries, a chorus that marked the boundary between night and morning. For Louisa Lowe, lying awake in her cell, these sounds were a daily reminder of where she was and what she had become in the eyes of the law. She was a certified lunatic, subject to the authority of the superintendent and the distant oversight of the commissioners in lunacy at Whitehall Place. Her letters could be opened, her movements controlled, her very words interpreted as symptoms of the condition she denied possessing. The corridors of the house were lit only from skylights set high in the ceiling, and these, Lowe observed, were never opened during her stay. The passages had no direct fresh air, and the atmosphere was close and stale. Between the bedrooms, unventilated closets sometimes rendered the rooms unendurably offensive. The architecture of the place was carceral in its logic, designed to contain and to observe, not to comfort or to heal. The windows in the cells opened only a few inches at the bottom, limiting both light and ventilation. In summer, the heat could be oppressive. In winter, the cold seeped through the walls and settled into the bones. Breakfast came at a fixed hour, and the patients gathered in the dining room under the supervision. At one house Lowe called Pond Hall, a pseudonym she used to protect herself from legal action, the thermometer over the fireplace sometimes read as low as 42 degrees Fahrenheit at the morning meal. The fires were lit sparingly and extinguished promptly after supper. Bedroom fires were rarely allowed, even when the cold was severe. The patients wrapped themselves in whatever coverings they could find and endured. The food, too, followed a strict. Lowe kept a dietary for 3 weeks at Pond Hall, recording what was served and in what quantity. Biscuits and toast were counted out, 1 per head. Meat in the summer months sometimes arrived at the table already tainted by the heat, and patients were expected to eat it regardless. The fees paid by private patients, often £200 to £400 a year, suggested a standard of care that the reality did not match. Lowe came to see the proprietary asylum as a business, its profits extracted from the bodies and minds of those who could not leave. The daily walk was the only regular escape from the house itself, and even this was hedged with restrictions. At Pond Hall, walks occurred at fixed hours, summer or winter, with no adjustment for weather or season. If rain fell at the appointed time, the walk was simply cancelled. In the heat of summer, patients were taken out at midday, meeting the fierce noontide rays of the sun, and never tasted the sweet morning air of the dog days except through the narrow slits of their windows. The grounds at Pond Hall included a garden and a pond, but the pond received a large amount of house sewage, and in certain atmospheric conditions, the effluvia rising from it were pestilential. Patients were driven from that part of the grounds when the smell grew too strong, and sometimes had to close their windows at night to keep out the stench. In the large metropolitan house, the good walkers went out twice a day in groups, accompanied by 1 or more keepers. Others, deemed violent or weak, took their exercise in a walled court, the gate locked behind. The keepers watched from a distance, and the patients moved in their prescribed circles, their freedom measured in paces and minutes. Louisa Lowe, who had once walked the lanes of Devon as she pleased, now walked where she was told when she was told, and returned to her cell at the appointed hour. The staff of these houses formed a hierarchy as rigid as the routine. At the top stood the proprietors and superintendents, often medical men or their families, who controlled admission, discipline, and release. Below them were the doctors, whose reports shaped the official record of each patient's condition. Then came the attendants and matrons, who administered the daily work of the house, unlocking doors, supervising meals, accompanying walks, and enforcing the. At Pond Hall, the matron was a woman of remarkably calm and eminently practical disposition, and Lowe noted with quiet irony that she had herself been previously incarcerated as a patient in the same system she now served. The patients themselves occupied the lowest rung, their civil rights suspended, their correspondence subject to inspection, their movements controlled by others. Lowe wrote letters. She wrote to solicitors in London, listing witnesses to her sanity and giving instructions for proceeding towards her liberation. She wrote to the commissioners in Lunacy, reporting on the drainage, the suppression of correspondence, the conditions she observed. She wrote to friends, hoping that her words would reach someone who could help. Many of these letters never arrived. The law allowed superintendents to open and read the correspondence of private patients, and in practice, Lowe alleged, letters were routinely suppressed or diverted. One letter to a solicitor, containing her lists of witnesses and her plans for legal action, was intercepted and shown to hostile parties. The fragile thread that might have connected her to the outside world was cut before it could be drawn taut. The commissioners in Lunacy were the official guardians of the system, charged with inspecting licensed houses and hearing the complaints of patients. Their office was at Whitehall Place, and they visited the metropolitan houses at least 6 times a year, in theory. In practice, Lowe observed, The visits sometimes clustered at the end of the year, with 4 or 5 months passing without inspection, and then a rapid succession of calls to meet the quota. When the commissioners came, they interviewed patients in private, or so the rules required. In practice, superintendents sometimes had private conversations with the commissioners beforehand, shaping the questions that would be asked. Lowe had 7 interviews with the commissioners during her incarceration. She found them courteous but unhelpful. The Lord Chief Justice himself had declared that the commissioners could have no possible motive for knowingly detaining a sane person. Lowe disagreed. She believed they had every motive to conceal the faults of a system they administered, and no appetite for the embarrassment that prosecutions would bring. The days passed. The locks turned. The bell rang. The walks came and went. Louisa Lowe, who had once been mistress of a vicarage, who had written letters and received visitors and moved through the world as a free woman, now counted biscuits and watched the thermometer and listened for the sound of the night keeper's round. She sustained herself with the hope that her story might one day help to show her country the true nature of its lunacy laws. She did not know in those long months whether that hope would ever be fulfilled. She only knew that she was not mad, that she had never been mad, and that the law had failed to protect her from those who said otherwise. The fragile connections that linked people in the outside world, partners, siblings, landlords, friends, were severed or strained by the fact of incarceration. A woman certified as a lunatic could not easily maintain her place in the lives of those who had known her. Her letters might not arrive. Her visitors might be discouraged or turned away. Her reputation, once the certificates were signed, was shadowed by the official judgment of insanity. Lowe knew other patients whose stories echoed her own. Women of good family, quiet habits and sound mind, confined on the word of a relative and the signature of a doctor, their protests dismissed as further evidence of their condition. The asylum was a place where the ordinary bonds of trust and affection could be broken, where the word of the confined counted for nothing against the word of those who held. And yet, even in such a place, small acts of solidarity and observation persisted. Lowe took notes. She recorded conversations, dietary details, the temperature of the dining room, the practices of the staff. She listened to the stories of other patients and remembered them. She watched the commissioners come and go, and she formed her own judgments about their methods and their motives. The mystery of how a sane woman could be confined among maniacs, and how she might ever escape, was one she studied with the care of a scholar and the urgency of a prisoner. The answer, she came to believe, lay not in the madness of individuals but in the structure of the law itself, a law that served the interests of some at the expense of others. The final confirmed sightings of Louisa Lowe as a free woman, before her first incarceration, are sparse in the record. She had been living in lodgings, the location unspecified, in the weeks before September 1870. The routine of her days is not described in detail, but she later wrote that she was quite sound in mind, and fairly so in body, at the time of her. There is no surviving account of her last ordinary morning, no letter written on the eve of her capture, no diary entry marking the boundary between liberty and confinement. The record simply notes that she was there, and then she was not. One of the medical certificates signed against her referred to an incident reported by her landlady. Lowe had rung for a light in the night and asked if some animal had not got into her room. This was offered as evidence of disordered mind. Another certificate mentioned her calling herself a medium and saying she could only write as God moved her fingers. Lowe denied having said this in the form alleged. She acknowledged an interest in spiritual matters, but insisted that her words had been distorted or misunderstood. The certificates, she believed, were built on trivialities and misrepresentations, inflated into grounds for incarceration. In September 1870, an able-bodied female appeared at her lodgings and invited her to accompany her to Brislington Proprietary Madhouse, near Bristol. The invitation was not a request. Lowe was taken. The journey from her lodgings to the asylum is not described in her writings, but the destination is clear. Brislington House was a large country asylum, with separate wards, locked single rooms, and a structured daily routine. It had received patients for decades, and its reputation was established among those who dealt in the confinement of the insane. Louisa Lowe arrived there as a certified lunatic, her liberty suspended by the signatures of 2 registered medical practitioners and the order of a relative or other person with legal standing to commit her. The silence that followed her removal was profound. Her letters, written from inside the asylum, were subject to the superintendent's discretion. Many did not reach their intended recipients. The friends and solicitors she hoped would intervene on her behalf did not always know where she was or what had become of her. The law allowed the person who signed the order of confinement to control, in practice, whether and when a private patient might be released. The commissioners in Lunacy had oversight, but their powers were limited, and their inclination to challenge the judgment of superintendents was, in Lowe's experience, weak. She was transferred in time from Brislington to a large metropolitan house adapted for 200 patients of both sexes. The exact date of this transfer is not given in the sources consulted, but the pattern of her confinement is clear. She moved from one institution to another, always as a certified patient, always under the authority of those who believed, or claimed to believe, that she was insane. At each house she observed the routines, recorded the conditions, and sought opportunities to communicate with the outside world. At each house, her efforts were frustrated by the suppression of correspondence and the indifference of those charged with her oversight. There came a point, after months of confinement, when an inquisition was anticipated. This was a formal legal proceeding, likely in chancery, to determine whether she was of unsound mind and to settle questions of her person and property. Lowe expected to face this process, to have her sanity tested before a jury or a judge. Instead, she was sent out of the asylum on terms she later compared to those of a ticket-of-leave convict, released but not vindicated, free but not cleared. The circumstances of her discharge are not fully detailed in the consulted sources, but she emerged from confinement without the official recognition that she had been wrongfully held. The violence of her incarceration was not physical, or not primarily so. There is no record of beatings or restraints applied to her person, though she knew of other patients who had suffered such treatment. The violence was structural. It lay in the locks and the bells and the suppression of letters. It lay in the power of a signature to erase a life. It lay in the gap between the law's promise of protection and the reality of its operation. Louisa Lowe lost years. She lost her place in the world. She lost the trust that the institutions of her country would defend her liberty. These losses are not visible in the record as wounds or scars, but they shaped everything that followed. After her release, she did not retreat into silence. She gathered her notes and her memories and began to write. She published pamphlets and a book, The Bastilles of England, describing what she had seen and suffered. She became honorary secretary of the Lunacy Law Reform Association, an organization dedicated to changing the laws that had failed her. She delivered a speech at the Cavendish Rooms in Mortimer Street, London, on the 17th of July, 1873, addressing an audience of strangers on the danger to society and personal liberty of the present lunacy. She called her address My Outlawry, and in it she recounted her experience and the experiences of others, building a case against the system that had confined her. The commissioners in Lunacy, the superintendents, the certifying doctors, none of them faced prosecution for what had been done to her. The Lord Chief Justice expressed confidence that the commissioners could have no possible motive for knowingly detaining a sane person. Lowe disagreed, but her disagreement did not result in legal consequences for those she accused. The courts did not declare her confinement wrongful. The system continued with its certificates and orders and locked doors, and other women and men continued to pass through it, some justly confined, others perhaps as unjustly as she believed herself to have been. The mystery of Louisa Lowe's case is not a mystery of blood or violence. It is a mystery of power and silence. How did it happen that a woman of sound mind, living quietly in lodgings, could be taken from her home and confined among maniacs for years? How did it happen that her letters were suppressed, her protests ignored, her liberty suspended on the word of doctors and relatives she could not challenge? The answer lies in the law itself, in the broad discretion it gave to those who signed certificates and orders, in the limited safeguards it provided for those who wished to contest their confinement, in the financial incentives that made the lunacy trade profitable for proprietors and indirectly for interested kin. Lowe spent years trying to answer these questions, to understand what had happened to her and how it could be prevented from happening to others. She did not succeed entirely. The law changed in time but slowly, and the abuses she described did not disappear overnight. Yet her voice was heard, her story was told, and her name became associated with a cause that outlived her. In the quiet of the Cavendish rooms, on a July evening in 1873, a woman who had been declared mad stood before an audience of strangers and spoke the truth as she understood. The record does not tell us what became of her in the years that followed, or where she is buried, or whether any stone marks her resting place. The archives hold fragments, not a complete portrait. What remains is her testimony, written and spoken, a document of survival and resistance in an era when the law could be turned against those it was meant to protect. The discovery of wrongful confinement is rarely a single moment. It does not announce itself with the clarity of a door flung open or a voice crying out in the night. Rather, it accumulates slowly, like sediment at the bottom of a still pond, until the water itself becomes clouded and the truth can no longer. For Louisa Lowe, the recognition that something was profoundly wrong came not in a flash of revelation, but through a gradual and painful assembly of evidence, gathered in corridors that smelled of carbolic and despair, in rooms where the thermometer read 42 degrees at breakfast, and in the careful, quiet conversations she held with women whose stories mirrored her own. The first discovery was personal, intimate, and devastating. It occurred in September of 1870, when Louisa found herself standing in the entrance hall of Brislington House, a large proprietary asylum near Bristol. The building presented itself as a place of healing, with its grounds and its separate wards and its air of medical respectability. Yet the moment she crossed its threshold, she understood that she had entered a world governed by different laws than those she had known. She was, as she later wrote, quite sound in mind and fairly so in body. But the certificates had been signed, the order had been given, and she was now, in the eyes of English law, a lunatic. The place itself offered the first evidence that something had gone terribly wrong. Brislington House was quiet, certainly quieter than the institutions she would later inhabit, but it was unmistakably a place of confinement. The doors were heavy, the locks were substantial. The windows, though they admitted light, did not invite escape. She was shown to a room, and the door was closed behind her, and she heard the sound that would become the constant accompaniment to her days and nights, the turning of a key in a lock. It was a sound that spoke not of care but of custody, not of treatment but of imprisonment. In those early days at Brislington, Louisa began to gather the fragments of understanding that would eventually form her case. She observed the other patients, some of whom were clearly unwell, their minds wandering in territories she could not follow. But she also observed women who seemed, to her careful eye, as rational as herself. They spoke sensibly. They conducted themselves with dignity. They asked questions that deserved answers and received none. And she began to wonder, with a growing sense of horror, how many of them had arrived here through the same mysterious process that had delivered her to this place. The certificates that justified her confinement became objects of intense interest. She learned in time what they contained. One referred to her landlady being alarmed by her ringing for a light in the night and asking whether some animal had got into her room. Another mentioned her calling herself a medium and claiming that she could only write as God moved her fingers. These were the grounds upon which her liberty had been taken. These were the facts that had transformed her from a clergyman's wife, living in the quiet seclusion of Uppertary Vicarage, into a patient in a madhouse. The discovery that the system itself was flawed came more slowly, through conversations and observations that accumulated over months. At Brislington, and later at a large metropolitan asylum adapted for 200 patients, Louisa began to understand the architecture of her captivity. The law required 2 certificates from registered medical practitioners and an order signed by a relative or other person. But the law did not require that the certifying doctors know the patient well, or that they conduct thorough examinations, or that they distinguish between eccentricity and genuine danger. Any registered practitioner in actual practice could certify. Any person with 2 certificates could order incarceration, and the person who signed the order had, in practice, almost exclusive power to determine when the patient might be released. The large metropolitan house offered new evidence of the system's failures. Here, Louisa encountered the full machinery of institutional confinement. The corridors were lit only from skylights that never opened during her stay, creating passages without direct fresh. The cells, as the bedrooms were frankly called, were secured with heavy jail locks that turned with a harsh, grating noise. At 9 in the evening, patients were escorted to these rooms and locked in. Half an hour later, an inspection. An hour after that, another. Very early in the winter mornings, an atrociously loud call bell would ring, and the house would stir into reluctant activity, with night keepers lighting candles and moving along the corridors, and patients in neighboring wards startled into shrieks and songs and cries. It was here that Louisa began to keep systematic records. She noted the routines, the restrictions, the small cruelties that were not cruelties in the eyes of those who administered them, but simply the way things were done. Good walkers went out twice a day in groups under keepers. Others took exercise in walled courts at set times, the gate locked behind them. Violent and suicidal patients were present, as were quieter inmates like herself. And she began to collect the stories of others, women who told her how they had come to be here, what had been written on their certificates, how long they had been confined. The discovery that her letters were being intercepted came as a particular. Louisa had written to solicitors, to friends, to the commissioners in Lunacy themselves, seeking legal assistance and reporting on conditions. She had composed careful letters containing lists of witnesses to her sanity and instructions for proceeding towards liberation. But these letters, she learned, had been shown to hostile parties. The law allowed superintendents to suppress correspondence from private patients, with the expectation that such letters would be shown to commissioners. In practice, Louisa alleged, letters were routinely suppressed and rerouted, cutting off the confined from any hope of outside help. The commissioners in Lunacy, seated at 19 Whitehall Place in London, were meant to be the safeguard against such abuses. They had statutory responsibility to inspect licensed houses, to review certificates and reports, and to hear complaints. Louisa would eventually have 7 interviews with them during her incarceration. But these interviews, she came to understand, were not what they appeared. The visits were meant to occur 6 times annually for metropolitan proprietary houses. In practice, she observed, 4 or 5 months might pass without a visit, followed by a rapid succession of inspections at the close of the year to meet the quota. And when commissioners did arrive, superintendents sometimes had private conversations with them before patients were seen, shaping the questions that would be asked and the conclusions that would be drawn. The discovery of the conditions at Pond Hall, where Louisa was later confined, added new dimensions to her understanding. This was a more intimate house, expensive and outwardly genteel, with garden grounds and a smaller number of patients. But the garden contained a pond that received a large amount of house sewage, producing effluvia so pestilential that patients were driven from that part of the grounds, and sometimes had to close windows at night to exclude the smell. The indoor arrangements created persistent foul odors that Louisa characterized as too foul and filthy for description. The day room faced north and was inadequate. The thermometer over the dining room fireplace became a focal point for patients monitoring the cold, sometimes reading as low as 42 degrees at breakfast. Fires were extinguished promptly after supper. Bedroom fires were rarely allowed. The dietary at Pond Hall became another piece of evidence. Louisa kept careful records for 3 weeks, noting what was served and how it was distributed. Picnic biscuits and pieces of toast were counted out one per. In summer, meat sometimes arrived tainted by the heat. The walks occurred at fixed hours, summer or winter, with no adjustment for weather. If rain fell at the stated hour, the walk was simply cancelled. In the dog days of summer, patients never tasted the sweet morning air, but were instead sent out at midday to meet the fierce noontide rays of the sun. Through all of this, Louisa was assembling a case, not for a court of law, though she would eventually seek legal redress, but for the court of public opinion. She was discovering, piece by piece, that the system designed to protect the vulnerable had become a system that could be turned against them. The certificates, the orders, the inspections, the interviews, all of it formed a structure that appeared to offer safeguards, but in practice offered very few. And she was discovering that she was not alone. The women she met in these institutions, some mad and some manifestly sane, were all caught in the same machinery, all subject to the same laws that could be wielded by relatives seeking control of property, by husbands seeking to silence inconvenient wives, by a lunacy trade that profited from every bed filled and every day of continued confinement. The moment of fullest discovery came not in an asylum, but in a courtroom and later in a public hall. On the 22nd of November, in a year she would remember with bitterness, Louisa's case was considered in Queen's Bench. She characterized the outcome as a cruel failure. The court did not accept her claim of wrongful confinement. She gained her liberty eventually, but not through judicial vindication. She was sent out of the asylum on terms she likened to those of a ticket of leave convict, released but not exonerated, free but not cleared. And so she turned to another kind of discovery, the discovery of her own voice. On the 17th of July, 1873, in the Cavendish Rooms on Mortimer Street in London, Louisa Lowe stood before an audience of strangers and delivered a speech she called My Outlawry. She spoke of the danger to society and personal liberty of the present lunacy laws. She spoke of her own experience and the experiences of others. She spoke of certificates signed on flimsy evidence, of letters intercepted, of commissioners who saw no reason to prosecute, of a system that protected its own interests rather than the liberty of its subjects. The discovery was now complete. The crime, if crime it was, had come to light, and Louisa Lowe had become its witness. To understand how such a thing could happen, one must understand the spaces in which it occurred, and the routes by which a person might pass from liberty to confinement without ever crossing a threshold marked as dangerous. The spatial logic of wrongful incarceration in Victorian England was not the logic of the prison or the courtroom. It was the logic of the private house, the licensed asylum, the medical certificate, and the family order. The routes were domestic. The access points were, and the evidence, such as it was, existed in documents that the subject herself might never see until it was too late. Consider first the geography of Louisa Lowe's confinement. She began at Uppertry Vicarage, near Honiton, in the quiet of Devon. This was her home, the residence of a clergyman's wife, a place of deep seclusion and country life. From here she was taken to Brislington House, near Bristol, a journey of some distance that carried her from the familiar landscape of her marriage into the unfamiliar territory of institutional care. Brislington was a large proprietary asylum, privately owned and licensed to receive paying patients. It stood in semi-rural surroundings, presenting an appearance of respectability that belied its function. The architecture was substantial. The grounds were But the interior was organized for control, with separate wards, locked single rooms, and a structured daily routine that left little space for autonomy. From Brislington, Louisa was transferred to a large metropolitan asylum adapted for 200 patients of both sexes. The exact location is not named in her writings, but it lay within the metropolitan districts of London, a dense urban environment where such institutions could operate with relative anonymity. This house was larger, busier, more overtly institutional. The corridors were long and lit only from skylights above. The cell doors were fitted with jail locks. The regime was more regimented, with inspections at night, early morning bells, and group walks under the supervision of the presence of violent and suicidal patients, alongside quieter inmates like Louisa, created an atmosphere of unpredictability, a constant reminder that one was in a place designed for the containment of those deemed dangerous to themselves or others. Later still, Louisa was moved to Pond Hall, a pseudonym she used to protect herself from legal action. This was a smaller, more expensive establishment, licensed for private patients and presenting itself as a genteel alternative to the larger asylums. The grounds included a garden and a pond, suggesting a suburban or semi-rural setting, but the pond received house sewage, and the effluvia it produced made parts of the grounds unusable. The day room faced north and was poorly heated. The bedrooms had windows that opened only a few inches at the bottom. The fires were extinguished after supper. The walks occurred at fixed hours regardless of weather. The gentility was a facade. The reality was discomfort, restriction, and the ever-present smell of inadequate sanitation. The routes by which a person entered these institutions were deceptively simple. English lunacy law for private patients required 2 certificates from registered medical practitioners and an order signed by a relative or other person. The certificates were meant to attest to the patient's unsoundness of mind. The order was meant to authorize the confinement, but the law allowed great discretion. Any registered practitioner in actual practice could certify. The examination need not be thorough, the evidence need not be substantial. A landlady's alarm at a nighttime bell, a reference to spiritual beliefs, an unconventional turn of phrase, these could be sufficient. And once the certificates were signed and the order was given, the patient was delivered to the asylum and the door was locked. The access points were legal, but they were also domestic. The person who signed the order had in practice almost exclusive power to determine when the patient might be released. This meant that a husband, a brother, a son, or any relative with sufficient motivation could initiate confinement and then control its duration. The patient had no automatic right to challenge the certificates, no guaranteed access to legal counsel, no certain means of communicating with the outside. Letters could be intercepted, visitors could be refused. The commissioners in lunacy might visit, but their visits were infrequent. Their interviews were sometimes conducted in the presence of superintendents, and their conclusions were often deferential to the medical authorities who ran the institutions. The forensic evidence in such cases was not the evidence of the modern. There were no blood tests, no fingerprints, no scientific instruments capable of measuring the presence or absence of mental illness. The evidence was documentary and testimonial. It consisted of the certificates themselves, with their brief descriptions of alleged symptoms. It consisted of the reports prepared by superintendents, documents that patients might never see and could not challenge. It consisted of the observations of attendants and keepers, whose testimony was shaped by their position within the institutional hierarchy. And it consisted of the patient's own behavior, interpreted through the lens of those who had already decided she was mad. Louisa Lowe read her certificates after her release and found them wanting. One referred to her landlady's alarm at a nighttime bell and a question about an animal. Another mentioned her calling herself a medium and claiming that she could only write as God moved her fingers. She denied having said this in the form recorded, but the certificates had been signed and the order had been given, and she had spent years in confinement on the basis of these documents. The forensic evidence, such as it was, had been assembled without her knowledge, interpreted without her input, and used against her without her consent. The competing theories of Louisa Lowe's case remain unresolved to this day. One theory, the official theory, held that she was genuinely unwell, that the certificates were accurate, that the confinement was justified, and that the commissioners acted in good faith throughout. The Lord Chief Justice, Cockburn, expressed confidence that commissioners could have no possible motive for knowingly detaining a sane person. The system in this view was imperfect but fundamentally sound, and Louisa's complaints were the product of a mind that had been, at least for a time, disordered. The other theory, Louisa's own theory, held that she was always sane, that the certificates were careless or false, that the confinement was motivated by greed or malice or both, and that the commissioners were complicit in a system that protected its own interests rather than the liberty of its subjects. She pointed to the lunacy trade, the proprietary asylums that profited from every bed filled, the fees of £200 to £400 per year that made confinement of those with property financially attractive. She pointed to the relatives who used lunacy procedures to gain control of a spouse's person or estate, to alter wills, or to restrain socially disapproved relationships. She pointed to the letters intercepted, the visits denied, the interviews conducted in the presence of those who had every reason to keep her confined. Cozy crime does not solve mysteries, it contemplates them, and the mystery of Louisa Lowe's confinement remains, in important respects, unsolved. The original medical certificates, the asylum case books, the commissioner's internal memoranda, these documents, if they survive, have not been fully examined in the sources available to us. We have Louisa's account, detailed and passionate and consistent, but we do not have the clinical notes that might confirm or contradict her version of events. We have the official confidence of the Lord Chief Justice, but we do not have access to the deliberations that led to that confidence. The evidence points in two directions, and the truth, whatever it may be, lies somewhere in the space between. What we can say with certainty is that the system allowed for it. The law gave broad powers to relatives, doctors, and asylum proprietors, with limited safeguards for the subject. The common law standard, articulated in Fletcher v. Fletcher in 1859, held that only persons both of unsound mind and dangerous to self or others could legitimately be restrained, but this standard was frequently ignored in practice. Patients were confined for eccentricity, for unconventional religious views, for inconvenient marriage. The investigation of wrongful confinement in Victorian England did not proceed as a criminal inquiry might. There were no detectives in the conventional sense, no constables knocking at doors with warrants, no evidence rooms where exhibits were catalogued and preserved. The system that held Louisa Lowe and others like her operated within its own enclosed world, with its own authorities, its own methods of examination, and its own standards. To understand how her case was investigated, and why it yielded the results it did, we must enter that world and observe its workings with the same careful attention she herself brought to her years of confinement. The commissioners in Lunacy held statutory responsibility for the oversight of private asylums throughout England. Their offices stood at 19 Whitehall Place in London, a short walk from the centres of government, and from those offices they dispatched visitors to inspect the licensed houses where patients like Lowe were held. The law required 6 inspections annually for metropolitan proprietary houses, a figure that sounds reassuring until one examines how it was achieved in practice. Lowe observed that months might pass without a single visit, followed by a rapid succession of inspections near the close of the year, as if the commissioners were hurrying to meet a quota rather than conducting genuine oversight. The pattern suggested bureaucratic compliance rather than vigilant protection. When commissioners did visit, they were empowered to interview patients privately, to examine certificates and reports, and to hear complaints. In theory, these interviews offered a lifeline to those who believed themselves wrongfully confined. A patient could speak directly to an official representative of the state, present evidence of sanity, and request release. In practice, the interviews were hedged about with difficulties that Lowe documented with precision. Superintendents sometimes remained present during what were meant to be confidential conversations. In other cases, the proprietor or medical officer had already spoken privately with the visiting commissioner before the patient was seen, shaping the questions that would be asked and the frame through which answers would be interpreted. A patient entering such an interview faced an invisible disadvantage. Her words weighed against professional opinions already formed. Lowe recounted 7 interviews with commissioners during her period of incarceration. She approached each one as an opportunity to demonstrate her rationality, to present the facts of her case, and to request the investigation she believed the law entitled her to receive. The outcomes disappointed her repeatedly. She found that commissioners treated the reports of superintendents as confidential documents, declining to share their contents with the patients they concerned. She could not know precisely what had been written about her, could not challenge specific allegations, could not confront the evidence upon which her continued detention rested. The process resembled a trial in which the accused was denied access to the charges. The methods available to commissioners were, in any case, limited by the assumptions embedded in the system. A patient who had been certified by 2 registered medical practitioners and committed by order of a relative arrived at the asylum already labeled. The certificates constituted a kind of official truth, and the burden of disproving them fell entirely upon the confined person. Lowe noted that the common law standard articulated in Fletcher v. Fletcher required both unsoundness of mind and danger to self or others before restraint could be justified. Yet in practice, this standard was frequently ignored. Patients were confined for eccentricity, for unconventional religious views, for behavior that embarrassed or inconvenienced their families. The certificates in Lowe's own case referred to her calling herself a medium and to alleged statements about God moving her fingers when she wrote. A landlady's reported alarm over a nighttime bell and suspicion of an animal in her room appeared as evidence of mental disturbance. These were the foundations upon which years of confinement rested. The suspects in Lowe's narrative were not individuals accused of a specific crime, but classes of actors whose collective behavior enabled wrongful confinement to occur and persist. She identified them with care, distributing responsibility across the system, rather than concentrating it upon any single villain. The proprietors and superintendents of proprietary asylums occupied the most visible position in her account. These were the men, and occasionally women, who ran the licensed houses as private businesses, receiving fees from the families of patients and maintaining establishments that ranged from small domestic arrangements to institutions housing 200 inmates. Lowe called them madness mongers, a term that captured her view of their A patient paying £200 to £400 annually represented a substantial income stream, one that would cease the moment she was discharged as recovered. The financial logic of the system created an incentive to retain patients longer than necessary, to interpret ambiguous behavior as evidence of continuing illness, and to resist the conclusion that a certified lunatic had regained her reason. She did not allege that all proprietors acted. Some, she acknowledged, maintained orderly houses and treated their charges with a degree of consideration. But the structure of the trade, as she understood it, rewarded retention over release. A superintendent who discharged patients promptly earned less than one who kept them. A house that developed a reputation for lengthy stays might attract families seeking to be rid of troublesome relatives for extended. The incentives pointed in one direction, and human nature, being what it is, tended to follow. The commissioners in Lunacy appeared in her account not as active persecutors but as passive enablers. Their statutory duty was to protect patients from abuse and to ensure that only the genuinely insane were confined. Yet Lowe believed they had failed in this duty, not through malice but through a kind of institutional self-interest. The commissioners administered a system, and the exposure of serious faults in that system would reflect poorly upon their administration. They had, she suggested, a direct interest in concealing infractions, because prosecutions and scandals would embarrass their oversight. When she reported breaches of the law, including the suppression of her correspondence and the unsanitary conditions at certain houses, she found that the commissioners saw no reason to prosecute. The machinery of accountability existed on paper but rarely engaged in practice. The certifying physicians occupied the first link in the chain of confinement. Any registered medical practitioner in actual practice could sign a certificate, and two such certificates, combined with an order from a relative, sufficed to commit a person to an asylum. The law placed no requirement that the certifying doctors be specialists in mental disease, that they have any prior acquaintance with the patient, or that they conduct more than a cursory examination. Lowe's certificates were signed by practitioners who, in her view, had recorded trivial or distorted incidents as evidence of lunacy. The landlady's alarm, the reference to spiritual beliefs, the minor domestic oddities that might characterize any household, these became the documentary foundation for years of incarceration. The doctors who signed such certificates bore responsibility for launching the process, yet they faced little accountability for errors. Once the patient entered the asylum, the certifying physicians moved on to other cases, their role. The relatives who signed orders of confinement remained largely in the background of Lowe's published account, though she made clear that the law gave them extraordinary power. The same person who ordered a patient's commitment held, in practice, exclusive authority to order her discharge. The commissioners could intervene in limited circumstances, and the Lord Chancellor possessed ultimate oversight, but in ordinary cases the committing relative controlled the patient's fate. This arrangement created obvious potential for abuse. A husband who wished to be rid of an inconvenient wife, a brother who coveted a sister's inheritance, an adult child impatient for a parent's estate, any of these could set the machinery in motion and then decline to reverse it. Lowe described cases among her acquaintance where such motives appeared to operate, though she did not detail the specific circumstances of her own commitment in the extracts that survive. The institutional context within which these actors operated deserves attention, for it shaped their behavior in ways that individual character alone cannot explain. The proprietary asylum was a hybrid creature, part medical institution and part commercial enterprise. It existed to confine and treat the insane, but it also existed to generate profit for its owners. These purposes did not always align. The medical mission called for careful diagnosis, appropriate treatment, and timely discharge when recovery occurred. The commercial mission called for full beds, satisfied paying families, and stable revenue. When the two came into conflict, the commercial interest often prevailed. The commissioners, for their part, operated within a framework of limited resources and competing priorities. They were responsible for inspecting dozens of licensed houses across England, reviewing hundreds of certificates and reports, and responding to complaints from patients, families, and concerned members of the public. Their visits, even when conscientiously conducted, could only sample the reality of asylum life. A superintendent who knew that commissioners would arrive on certain dates could prepare accordingly, ensuring that the house appeared orderly, that troublesome patients were quieted, and that any irregularities were temporarily concealed. The inspections provided a check upon the worst abuses, but they could not penetrate the daily texture of institutional life. The legal framework itself created conditions favorable to wrongful confinement. The requirement of 2 medical certificates sounds like a safeguard, but in practice it proved easy to satisfy. Doctors who made their living partly from asylum referrals had reason to maintain good relations with families seeking to commit relatives. The certificates required only that the practitioner state facts indicating insanity, and the definition of what constituted such facts remained broad and subjective. Spiritualist beliefs, unconventional religious expressions, domestic eccentricities, marital discord, any of these might be recorded as evidence of mental disturbance if the certifying doctor chose to interpret them so. The absence of effective appeal mechanisms compounded the problem. A patient who believed herself wrongfully confined could write to the commissioners, but her letters might be intercepted by the superintendent. She could request a private interview during inspections, but the interview might be compromised by prior conversations between officials and staff. She could seek legal assistance, but her correspondence with solicitors might be suppressed. Lowe described writing a detailed letter to a London solicitor, listing witnesses to her sanity and instructions for proceeding toward liberation. The letter was intercepted and shown to parties hostile. The very act of seeking help became evidence against her, proof of the scheming and manipulation that allegedly characterized the insane mind. The suspects in this quiet crime were thus not individual malefactors, but participants in a system that permitted and even encouraged abuse. Some acted from greed, some from institutional loyalty, some from genuine if mistaken belief in the rightness of their judgment. The evidence points in multiple directions, and the truth lies somewhere in the space between competing accounts. What we can say with certainty is that the system allowed for abuse, and that Louisa Lowe experienced its workings from the inside, observing with a clarity that confinement could not demand. The response to cases of alleged wrongful confinement reveals much about the assumptions and anxieties of Victorian society. The press, the public, and the institutions of government each reacted in characteristic ways, and their reactions illuminate the broader historical moment in which Louisa Lowe's ordeal occurred. Newspaper coverage of lunacy matters followed a particular pattern. Sensational cases, especially those involving violence or scandal among the upper classes, attracted intense attention. When a father's cruelty toward his children came to light, as in the case Lowe referenced involving a man named Echel, the papers reported hideous tales of insane crime that startled the public and sold copies. Such stories confirmed comfortable assumptions about the nature of madness, presenting it as dramatic, dangerous, and unmistakably different from ordinary. The insane in these accounts were recognizably other, their behavior so extreme that confinement seemed not merely justified but necessary for public safety. Wrongful confinement presented a more troubling narrative, one that the press approached with less enthusiasm. Here the alleged lunatic was not wild-eyed and violent, but calm, articulate, and indistinguishable in manner from any respectable member of society. The story lacked the clear moral structure of the sensational. There was no obvious villain, no dramatic act of violence, no satisfying resolution in which justice triumphed over evil. Instead, there were competing claims, ambiguous evidence, and uncomfortable questions about the reliability of medical judgment and the motives of families. Such stories appeared from time to time, surfacing through coroner's inquests or parliamentary debates, but they did not capture public imagination in the same way. The harrowing tales of ill usage that Lowe mentioned emerged intermittently, generating brief concern before fading from attention. The tone of press reporting on wrongful confinement tended toward the somber rather than the sensational. Journalists who covered such cases faced a difficulty. The alleged victim claimed sanity, but 2 medical practitioners had certified otherwise. To accept the patient's account was to impugn the judgment of qualified professionals, and by extension, the system that licensed them to make such judgments. To accept the official account was to dismiss the patient's testimony as the product of the very condition it denied. Most reporters chose caution, presenting the facts without strong editorial commitment to either interpretation. The result was coverage that informed without inflaming, that raised questions without answering. Public reaction to wrongful confinement cases was similarly muted. The general population had little direct contact with the asylum system, and little reason to believe that its workings might one day touch their own lives. Madness was something that happened to other people, to those whose minds had given way under strain or whose families bore the taint of hereditary. The comfortable classes could read of asylum conditions with a mixture of pity and relief, grateful that such places existed to contain those who could not function in ordinary society. The possibility that a sane person might be confined among the insane was disturbing precisely because it suggested that the boundary between sanity and madness was less secure than most people wished to believe. Lowe captured this public indifference with a phrase that resonates across the years: out of sight, out of mind. The asylum walls separated the confined from the free, and that separation was psychological as well as physical. Those outside the walls preferred not to think too closely about what occurred within. The patients were cared for, the doctors were qualified, the commissioners conducted their inspections. The system functioned, and its functioning absolved the public of further concern. Yet there were those who refused to look away. The formation of the Lunacy Law Reform Association, in which Lowe served as honorary secretary, indicated that a movement existed to challenge prevailing practices. The association drew together former patients, sympathetic physicians, lawyers troubled by procedural deficiencies, and reformers motivated by broader principles of personal liberty. They organized meetings, published pamphlets, and lobbied for legislative change. Their efforts kept the question of wrongful confinement before the public and parliamentary attention, even when the majority preferred to ignore it. The broader historical moment provided context for these efforts. The 1870s saw continued debate over the boundaries of state power and individual rights, debates that touched on matters far beyond lunacy. Questions of personal liberty, of the proper limits of professional authority, of the rights of women within marriage, all formed part of the intellectual atmosphere in which Lowe's case unfolded. Her situation exemplified several of these concerns simultaneously. As a married woman, she faced legal disabilities that limited her ability to pursue remedies against those she believed had wronged her. As a person labeled insane, she lost civil rights that would otherwise have protected. As a critic of established institutions, she challenged the authority of medical professionals and government officials who claimed to act in the public interest. Parliamentary attention to lunacy law had a long history by the time Lowe delivered her speech at the Cavendish Rooms in July 1870. A select committee had examined the lunacy laws in 1859, and another would convene in 1877 to inquire into the security afforded against violations of personal liberty. These committees heard testimony from medical experts, legal authorities, former patients, and asylum administrators. The evidence they gathered revealed a system that functioned reasonably well in many cases, but that contained structural vulnerabilities permitting serious abuse. Witnesses before the 1877 committee, including Dr. Mortimer Granville and Dr. Lockhart Robertson, offered critical assessments of over-detention and inadequate safeguards. Their testimony added professional weight to the concerns that patients like Lowe had raised from personal experience. The competing events of the era inevitably drew attention away from lunacy reform. The 1870s brought political crises, imperial concerns, economic fluctuations, and social controversies that commanded public interest more readily than the technical details of asylum inspection or the procedural requirements for certification. A parliamentary debate on wrongful confinement might share column space with reports of foreign wars, domestic scandals, or the latest developments in science and industry. The lunacy reformers worked against this tide of competing news, seeking to maintain focus on an issue that lacked the immediate drama of other causes. The response of official institutions to criticism followed predictable lines. The commissioners in Lunacy defended their record, pointing to the inspections they conducted, the complaints they investigated, and the improvements they had encouraged. They acknowledged that individual cases of wrongful confinement might occur, but maintained that the system as a whole provided adequate protection. The Lord Chief Justice, in remarks Lowe quoted, expressed confidence that commissioners could have no possible motive for knowingly detaining a sane person. This official confidence contrasted sharply with the experiences Lowe and others described, creating a gap between institutional self-assessment and patient testimony that neither side could bridge. The legal proceedings in Lowe's own case illustrated the difficulty of obtaining redress through the courts. She referred to a hearing in Queen's Bench on 22 November, in which her claim of wrongful confinement was considered. The outcome she characterized as a cruel failure, the court declining to accept her account. The legal standard for proving wrongful confinement was demanding. A plaintiff had to demonstrate not merely that she was sane, but that those who confined her knew or should have known she was sane and acted improperly nonetheless. The existence of medical certificates created a presumption of legitimacy that was difficult. Doctors who had signed in good faith, however mistakenly, were protected from liability. Superintendents who had relied upon valid certificates could claim they had followed proper procedure. The system insulated its participants from consequences, even when the results for patients were devastating. Lowe gained her liberty eventually, though not through legal vindication. She described being sent out of the asylum on terms she compared to those. The places where Louisa Lowe suffered still stand, though their purposes have long since changed. Brislington House, that large proprietary asylum near Bristol, where she was first confined in September 1870, remains in altered form upon its original grounds. The building has passed through many hands and many uses across the intervening century and a half. Its function as a private madhouse ended generations ago. Today one may walk the lanes nearby and see the structure that once held her, its walls now given over to quieter occupations. The heavy locks are gone. The cells where patients lay listening to the harsh turning of jail lock doors in the night have been converted to other rooms, other lives. The skylights that never opened during her stay may still admit pale English light, but they no longer seal in the stale air of confinement. Whitehall Place in London, where the commissioners in Lunacy kept their offices at number 19, continues as an administrative district. The particular rooms where Lowe sat through 7 interviews, pressing her case for liberty, have been absorbed into the ordinary business of government. No plaque marks the spot where she pleaded with officials who held the power to free her but declined to act. The building stands among others of its kind, unremarkable to those who pass without knowledge of what once transpired within. The asylum she called Pond Hall in her writings, with its garden pond receiving house sewage and its north-facing day room where the thermometer sometimes read 42 degrees at breakfast, has left fewer traces in the. She gave it a pseudonym to protect herself from legal retaliation, and that caution has made it difficult for later researchers to identify the site with certainty. It may still stand somewhere in the metropolitan districts, converted to flats or offices or some other use that bears no memory of the women who shivered there in inadequate clothing, forbidden to walk in the sweet morning air of summer. The Cavendish Rooms on Mortimer Street, where Lowe delivered her speech, My Outlawry, on the 17th of July 1873, have likewise been transformed by time. The hall where she stood before an audience of ladies and gentlemen, recounting her ordeal and demanding reform, has seen many gatherings since. Her voice does not echo there now, but her words survive in print, preserved in pamphlets and books that found their way into libraries and archives. The Yale Medical Library holds a copy of the Bastilles of England. The British Library and the National Archives maintain records from the period, including asylum registers, commissioners' reports, and parliamentary papers that document the system she fought against. The archival record confirms the broad outlines of her account. Medical certificates from the era routinely cited trivial incidents as evidence of insanity. A woman who rang for a light in the night and asked whether some animal had entered her room could find that moment recorded as proof of mental disturbance. A woman who expressed unconventional religious views, who spoke of spiritual matters in language that unsettled her listeners, could be labeled a medium and confined on the strength of that label. The certificates that sent Lowe to Brislington mentioned such things. She read them after her release and found them full of what she called foul and false allegations, distortions of ordinary behavior into symptoms of madness. The commissioners' records, where they survive, show the procedural regularity that Lowe described with such bitter precision. Visits were logged, reports were filed, letters from patients were noted as received, though many were never forwarded to their intended recipient. The system documented itself thoroughly, creating an appearance of oversight that masked, in her view, a fundamental failure to protect the liberty of those it claimed to serve. Parliamentary papers from the Select Committees of 1859 and 1877 preserve the testimony of medical men who questioned the adequacy of existing safeguards. Dr. Mortimer Granville told the later committee that patients were sometimes detained long after any legitimate medical purpose had been served. Dr. Lockhart Robertson offered similar concerns. Their words entered the official record alongside the complaints of former patients and the defenses of asylum proprietors. The debate continued for decades, each inquiry producing recommendations, each recommendation meeting resistance from those who profited from the existing arrangements. Lowe's own contribution to that debate was substantial. As honorary secretary of the Lunacy Law Reform Association, she corresponded with sympathizers, organized public meetings, and kept the question of wrongful confinement before the public eye. Her pamphlet Gagging in Mad Houses addressed the suppression of patients' correspondence. Her longer work, The Bastilles of England, provided a detailed account of conditions inside proprietary asylums, drawing on her own experience and on the testimony of others she had met during her incarceration. She named no names that might expose her to prosecution for libel, but she named practices, and she named the laws that permitted them. The legal standard she confronted remained formidable throughout her campaign. To prove wrongful confinement, a plaintiff had to demonstrate not merely that she was sane, but that those who confined her knew or should have known she was sane and acted improperly nonetheless. The existence of medical certificates created a presumption of legitimacy that courts were reluctant to disturb. Doctors who had signed in good faith, however mistakenly, enjoyed protection from liability. Superintendents who had relied upon valid certificates could claim they had followed proper procedure. The system insulated its participants from consequences, distributing responsibility so widely that no single actor could be held accountable for the suffering of those caught within it. Lowe gained her liberty eventually, though not through legal vindication. She described being sent out of the asylum on terms she compared to those of a ticket-of-leave convict, released not because anyone admitted error, but because continued confinement had become inconvenient. An inquisition had been anticipated, a formal chancery proceeding that would have examined her mental state before a jury. Rather than face that scrutiny, those who controlled her fate chose to let her go. She emerged into a world that had continued without her, carrying the knowledge of what she had seen and the determination to ensure others would see it too. The changes she sought came slowly and never completely. Later mental health legislation in Britain introduced tighter procedural safeguards, clearer definitions of the conditions that could justify detention, and stronger rights for patients to communicate with the outside world. The proprietary asylum system gradually gave way to public institutions and eventually to community-based care. The commissioners in Lunacy were replaced by other bodies with other names, and one hopes other habits of oversight. Whether these reforms would have satisfied Louisa Lowe is impossible to know. She had seen how easily procedural safeguards could become mere formalities, how readily those charged with protecting liberty could become complicit in its denial. Her burial site is not recorded in the sources that preserve her public work. We do not know where she rests or whether any stone marks the place. The archives hold her words but not her remains. She exists now as a voice in old pamphlets, a name in parliamentary indexes, a case study in histories of psychiatry and law. Scholars who write about Victorian asylums cite her testimony. Students who study the history of civil liberties encounter her argument. She has become one of the witnesses whose accounts help later generations understand what confinement meant for those who experienced it, and what it cost them. What her case reveals about the era is not comfortable knowledge. It shows how readily the language of medicine could be turned to purposes of control. It shows how gender and class and religious nonconformity could combine to make a woman vulnerable. It shows how systems designed to protect the public from the dangerous could be used to silence the inconvenient. And it shows how difficult it was, and perhaps still is, to reclaim a reputation once the label of madness had been applied. Lowe spent years of her life confined among those she considered genuinely ill, subjected to routines designed for the management of disorder, deprived of privacy and autonomy, and the simple freedom to walk in. She emerged determined to bear witness, and she did. The night is late now. The records have been consulted, the locations visited in imagination if not in body. The story has been told as fully as the sources allow, with their gaps and silences acknowledged. What remains is to honor the woman at its center, not as a case or a cause, but as a person who suffered and who refused to let that suffering be forgotten. Louisa Lowe asked to be believed. She asked that her testimony be weighed against the official confidence of those who had confined her. She asked that the law be changed so that others would not endure what she had endured. In her own time, she received partial answers at best. The courts did not vindicate her. The commissioners did not apologize. The doctors who signed her certificates faced no consequences. But she wrote her book, and she gave her speech, and she kept the Lunacy Law Reform Association alive. She did what she could with the tools available to her, and she left a record that outlasted the institutions she opposed. Tonight, as the hour grows late and the world outside grows quiet, we may think of her not in the asylum but before it, in the country seclusion she described, in the vicarage at Outlawry, where she lived before the attendant came to take her away. We may imagine her in a garden, perhaps, or at a window looking out over fields, in a time before the certificates and the locks and the long struggle for liberty. We may let that image stand as a kind of restoration, a return to the peace that was taken from her. Enclosing the vicarage at Outlawry stands quiet beneath the stars, its windows dark, its garden still. Somewhere a night bird calls and falls silent. The fields stretch away into shadow, and the air carries the scent of earth and growing things. We remember Louisa Lowe, who asked only to be heard and who made certain that she was. Thank you for listening. Whenever you wish, you will find us here. Rest well. A peaceful night to you.